Title 16 Pledge, Mortgage, and Anticreases. Chapter 1 Provisions Common to Pledge and Mortgage, 2085. The following requisites are essential to the contracts of pledge and mortgage. 1. That they be constituted to secure the fulfillment of principal obligation. 2. That the pledger or mortgager be the absolute owner of the thing pledged or mortgaged. 3. That the persons constituting the pledge or mortgage have the free disposal of their property, and in the absence thereof, that they be legally authorized for the purpose. Third persons who are not parties to the principal obligation may secure the latter by pledging or mortgaging their own property. 2086. The provisions of Article 2052 are applicable to a pledge or mortgage. 2087. It is also of the essence of these contracts that, when the principal obligation becomes due, the things in which the pledge or mortgage consists may be alienated for the payment to the creditor. 2088. The creditor cannot appropriate the things given by way of pledge or mortgage or dispose of them. Any stipulation to the contrary is null and void. 2089. A pledge or mortgage is indivisible, even though the debt may be divided among the successors in interest of the debtor or of the creditor. Therefore, the debtor's heir who has paid a part of the debt cannot ask for the proportionate extinguishment of the pledge or mortgage as long as the debt is not completely satisfied. Neither can the creditor's heir who received his share of the debt return the pledge or cancel the mortgage, to the prejudice of the other heirs who have not been paid. From these provisions is excepted the case in which, there being several things given in mortgage or pledge, each one of them guarantees only a determinate portion of the credit. The debtor in this case shall have a right to the extinguishment of the pledge or mortgage as the portion of the debt for which each thing is specially answerable is satisfied. 2090. The indivisibility of a pledge or mortgage is not affected by the fact that the debtors are not solidarily liable. 2091. The contract of pledge or mortgage may secure all kinds of obligations, be they pure or subject to a suspensive or resolutory condition. 2092. A promise to constitute a pledge or mortgage gives rise only to a personal action between the contracting parties, without prejudice to the criminal responsibility incurred by him who defrauds another by offering in pledge or mortgage as unencumbered things which he knew were subject to some burden, or by misrepresenting himself to be the owner of the same. Chapter 2 Pledge, 2093. In addition to the requisites prescribed in Article 2085, it is necessary, in order to constitute the contract of pledge, that the thing pledged to be placed in the possession of the creditor or of a third person by common agreement. 2094. All movables which are within commerce may be pledged, provided that they are susceptible of possession. 2095. Incorporeal rights evidenced by negotiable instruments, bills of lading, shares of stock, bonds, warehouse receipts, and similar documents may also be pledged. The instrument proving the right pledge shall be delivered to the creditor and, if negotiable, must be endorsed. 2096. A pledge shall not take effect against third persons if a description of the thing pledged and the date of the pledge do not appear in a public instrument. 2097. With the consent of the pledgee, the thing pledged may be alienated by the pledger or owner subject to the pledge. The ownership of the thing pledged is transmitted to the vendee or transferee as soon as the pledgee consents to the alienation, but the latter shall continue in possession. 2098. The contract of pledge gives a right to the creditor to retain the thing in his possession or in that of a third person to whom it has been delivered until the debt is paid. 2099. The creditor shall take care of the thing pledged with the diligence of a good father of a family. He has a right to the reimbursement of the expenses made for its preservation and is liable for its loss or deterioration in conformity with the provisions of this code. 2100. The pledgee cannot deposit the thing pledged with a third person unless there is a stipulation authorizing him to do so. The pledgee is responsible for the acts of his agents or employees with respect to the thing pledged. 2101. The pledger has the same responsibility as a bailer in commodatum in the case under Article 1951. 2102. If the pledge earns or produces fruits, income, dividends, or interests, the creditor shall compensate what he receives with those which are owing him. But if none are owing him, or in so far as the amount may exceed that which is due, he shall apply it to the principal. Unless there is a stipulation to the contrary, the pledge shall extend to the interest and earnings of the right pledged. In case of a pledge of animals, their offspring shall pertain to the pledger or owner of the animals pledged, but shall be subject to the pledge if there is no stipulation to the contrary. 2103. Unless the thing pledged is expropriated, the debtor continues to be the owner thereof. Nevertheless, the creditor may bring the actions which pertain to the owner of the against a third person. 2104. Pledged without the authority of the owner, and if he should do so or should misuse the thing in any other way, the owner may ask that it be judicially or extrajudicially deposited. When the preservation of the thing pledged requires its use, it must be used by the creditor but only for that purpose. 2105. A debtor cannot ask for the return of the thing pledged against the will of the creditor unless and until he has paid the debt and its interest with expenses in a proper case. 2106. If through the negligence or willful act of the pledgee, the thing pledged is in danger of being lost or impaired, the pledger may require that it be deposited with a third person. 2107. If there are reasonable grounds to fear the destruction or impairment of the thing pledged without the fault of the pledgee, the pledger may demand the return of the thing upon offering another thing in pledge, provided the latter is of the same kind as the former and not of inferior quality, and without prejudice to the right of the pledgee under the provisions of the following article. The pledgee is bound to advise the pledger, without delay, of any danger to the thing pledged. 2108. If, without the fault of the pledgee, there is danger of destruction, impairment, or diminution in value of the thing pledged, he may cause the same to be sold at a public sale. The proceeds of the auction shall be a security for the principal obligation in the same manner as the thing originally pledged. 2109. If the creditor is deceived on the substance or quality of the thing pledged, he may either claim another thing in its stead or demand immediate payment of the principal obligation. 2110. If the thing pledged is returned by the pledgee to the pledger or owner, the pledge is extinguished. Any stipulation to the contrary shall be void. If subsequent to the perfection of the pledge, the thing is in the possession of the pledger or owner, there is prima facie presumption that the same has been returned by the pledgee. The same presumption exists if the thing pledged is in the possession of a third person who has received it from the pledger or owner after the constitution of the pledge. 2111. A statement in writing by the pledgee that he renounces or abandons the pledge is sufficient to extinguish the pledge. For this purpose, neither the acceptance by the pledger or owner nor the return of the thing pledged is necessary, the pledgee becoming a depositary. 2112. The creditor to whom the credit has not been satisfied in due time may proceed before a notary public to the sale of the thing pledged. This sale shall be made at a public auction and with notification to the debtor and the owner of the thing pledged in the proper case, stating the amount for which the public sale is to be held. If at the first auction the thing is not sold, a second one with the same formalities shall be held, and if at the second auction there is no sale either, the creditor may appropriate the thing pledged. In this case, he shall be obliged to give an acquittance for his entire claim. 2113. At a public auction, the pledger or owner may bid. He shall, moreover, have a better right if he should offer the same terms as the highest bidder. The pledgee may also bid, but his offer shall not be valid if he is the only bidder. 2114. All bids at a public auction shall offer to pay the purchase price at once. If any other bid is accepted, the pledgee is deemed to have received the purchase price as far as the pledger or owner is concerned. 2115. The sale of the thing pledged shall extinguish the principal obligation, whether or not the proceeds of the sale are equal to the amount of the principal obligation, interest, and expenses in the proper case. If the price of the sale is more than said amount, the debtor shall not be entitled to the excess, unless it is otherwise agreed. If the price of the sale is less, neither shall the creditor be entitled to recover the deficiency, notwithstanding any stipulation to the contrary. 2016. After the public auction, the pledgee shall promptly advise the pledger or owner of the result thereof. 2117. Any third person who has any right in or to the thing pledged may satisfy the principal obligation as soon as the latter becomes due and demandable. 2118. If a credit which has been pledged becomes due before it is redeemed, the pledgee may collect and receive the amount due. He shall apply the same to the payment of his claim and deliver the surplus, should there be any, to the pledger. 2119. If two or more things are pledged, the pledgee may choose which he will cause to be sold, unless there is a stipulation to the contrary. He may demand the sale of only as many of the things as are necessary for the payment of the debt. 2120. If a third person secures an obligation by pledging his own movable property under the provisions of Article 2085, he shall have the same rights as a guarantor under Articles 2066 to 2070 and Articles 277 to 2081. He is not prejudiced by any waiver of defense by the principal obligor. 2121. Pledges created by operation of law, such as those referred to in Articles 546, 1731, and 1994, are governed by the foregoing articles on the possession, care, and sale of the thing, as well as on the termination of the pledge. However, after payment of the debt and expenses, the remainder of the price of the sale shall be delivered to the obligor. 2122. And a thing under a pledge by operation of law may be sold only after demand of the amount for which the thing is retained. The public auction shall take place within 1 month after such demand. If, without just grounds, the creditor does not cause the public sale to be held within such period, the debtor may require the return of the thing. 2123. With regard to pawnshops and other establishments which are engaged in making loans secured by pledges, the special laws and regulations concerning them shall be observed, and subsidiarily the provisions of this title. Chapter 3. Mortgage. 2124. Only the following property may be the subject of a contract of mortgage. 1. Immovables. 2. Alienable real rights in accordance with the laws imposed upon immovables. Nevertheless, movables may be the object of a chattel mortgage. 2125. In addition to the requisites stated in Article 2085, it is indispensable, in order that a mortgage may be validly constituted, that the document in which it appears be recorded in the registry of property. If the instrument is not recorded, the mortgage is nevertheless binding between the parties. The persons in whose favor the law establishes a mortgage have no other right than to demand the execution and the recording of the document in which the mortgage is formalized. 2126. The mortgage directly and immediately subjects the property upon which it is imposed, whoever the possessor may be, to the fulfillment of the obligation for security it was constituted. 2127. The mortgage extends to the natural accessions, to the improvements, growing fruits, and the rents or income not yet received when the obligation becomes due, and to the amount of the indemnity granted or owing to the proprietor from the insurers of the property mortgaged, or in virtue of expropriation for public use, with the declarations, amplifications, and limitations established by law, whether the estate remains in the possession of the mortgagor or it passes into the hands of a third person. 2128. The mortgage credit may be alienated or assigned to a third person in whole or in part with the formalities required by law. 2129. The creditor may claim from a third person in possession of the mortgaged property the payment of the part of the credit secured by the property which said third person possesses, in terms and with the formalities which the law establishes. 2130. A stipulation forbidding the owner from alienating the immovable mortgage shall be void. 2131. The form, extent, and consequences of a mortgage, both as to its constitution, modification, and extinguishment, and as to other matters not included in this chapter, shall be governed by the provisions of the mortgage law and of the land registration law. Chapter 4. Anticreases. 2132. By the contract of anticreases, the creditor acquires the right to receive the fruits of an immovable of his debtor, with the obligation to apply them to the payment of the interest, if owing, and thereafter the principal of his debt. Credit. 2133. The actual market value of the fruits at the time of the application thereof to the interest and principal shall be the measure of such application. 2134. The amount of the principal and of the interest shall be specified in writing, otherwise the contract of anticreases shall be void. 2135. The creditor, unless there is a stipulation to the contrary, is obliged to pay the taxes and charges upon the estate. He is also bound to bear the expenses necessary for its preservation and repair. The sum spent for the purposes stated in this article shall be deducted from the fruits. 2136. The debtor cannot reacquire the enjoyment of the immovable without first having totally paid what he owes the creditor, but the latter, in order to exempt himself from the obligation imposed upon him by the preceding article, may always compel the debtor to enter again upon the enjoyment of the property, except when there is a stipulation to the contrary. 2137. The creditor does not acquire the ownership of the real estate for non-payment of the debt within the period agreed upon. Every stipulation to the contrary shall be void, but the creditor may petition the court for the payment of the debt or the sale of the real property. In this case, the rules of court and the foreclosure of mortgages shall apply. 2138. The contracting parties may stipulate that the interest upon the debt be compensated with the fruits of the property which is the object of the anticreases, provided that if the value of the fruits should exceed the amount of interest allowed by the laws against usury, the excess shall be applied to the principal. 2139. The last paragraph of Article 2085 and Articles 2089 to 2091 are applicable to this contract. Chapter 5. Chattel Mortgage. 2140. By a chattel mortgage, personal property is recorded in the chattel mortgage register as a security for the performance of an obligation. If the movable, instead of being recorded, is delivered to the creditor or a third person, the contract is a pledge and not a chattel mortgage. 2141. The provisions of this code on pledge, insofar as they are not in conflict with the chattel mortgage law, shall be applicable to chattel mortgages.